Welcome to this presentation on the Pakistan Penal Code of 1860. Today we will conduct a comprehensive study of its enactment, the fundamental concepts it introduces, and its structural core. This document serves as the primary basis for criminal law in the region, and over the next several slides, we will unpack how it defines justice and maintains social order through its historical and legal framework. We begin by tracing the historical background and the origins of the Pakistan Penal Code. Understanding the roots of this legislation is essential to grasping how it functions today. This code represents a significant point in legal history, moving away from unstructured customs toward a centralized statutory authority that has governed the legal landscape for generations. Looking at its colonial legal origin, the code was drafted by the First Law Commission of India, which was famously chaired by Thomas Babington Macaulay. The foundational basis of the code is primarily English common law, though it was carefully adapted to fit local circumstances and regional needs. While it was enacted later, the code was actually drafted as early as 1837, specifically for this region. Following the creation of the country, there was a clear post-independence continuity as Pakistan adopted the original code in 1947. Through a careful adaptation process, key amendments were made to align the code with Islamic jurisprudence and constitutional principles. This enduring framework has remained the legal backbone of the nation for over 160 years, proving its remarkable resilience. Now, let us examine the core definitions that define this document. It is vital to understand the precise legal context of the words penal and code. These two terms define the scope and the organizational methodology of the entire legal instrument, setting the stage for how crimes are categorized and how laws are accessed by the legal community. In defining penal, we find its origin in the Latin word poenalis, which translates to relating to punishment. This part of the law specifically defines the acts or omissions that constitute a crime against the public. Additionally, it prescribes the necessary corrections by establishing clear legal boundaries for fines, imprisonment, and various physical measures used in the penal system. When we define a code, we are talking about a systematic consolidation of laws, rules, and statutes. These are arranged in a logical sequence within a legal handbook to ensure clarity and accessibility for all users. The primary advantages of codification are that it offers judicial certainty by organizing previously fragmented statutes and prevents the overlap or conflict between different laws. We will now transition into the implementation details of the code. This covers the journey from the initial enactment to its full enforcement across the territory. This process involved not only the passing of the law itself, but also the creation of the necessary judicial infrastructure to support its application in daily life. Regarding the enactment and enforcement timeline, the Imperial Legislative Council enacted the statute on October 6, 1860. However, extensive enforcement preparation was required, including the training of courts and magistrates. Consequently, actual enforcement did not take place until January 1, 1862, following a 2-year operational gap that allowed the legal machinery to be fully prepared. The significance of the year 1860 is profound. It marked a global shift toward modern codification in criminal law. This transition represented a major legal precedent shift, replacing complex common law with clear, written statutory rules. Its century-long resilience is evident today, as its robust design continues to form the essential foundation of Pakistan's contemporary trial system. Moving forward to the structural framework, we will now examine the anatomy of the Pakistan Penal Code. This provides the foundational overview necessary to understand how the law is organized and how various legal components interact within the penal system's architecture. The code structure is organized into 23 distinct chapters, covering diverse legal topics from general exceptions to specific offenses. It contains a total of 511 codified sections that define specific crimes and provide clear punitive guidelines. As substantive law, its primary role is to define crimes and dictate legal punishments, which distinguishes it clearly from procedural laws. Now we turn to the criminal liability matrix, which is built on two essential pillars. First is actus reus, or the act, which refers to the physical act of committing a crime or a specific omission that violates a legal duty. Second is mens rea, meaning the guilty mind, which involves the mental element of planning, intent, or knowledge behind the crime. The core principle to remember is that criminal liability equals actus reus plus mens rea.